of the City of London, Vatican City, and City of Washington, claims it is an independent entity that is not subject to any national authority, has its own laws, and pays no taxes. The aforementioned empire usurps the monetary, spiritual, and military fate of nations through the Bank of England, located on the City of London Corporation, hereinafter the Crown, to which the monetary interests are controlled by the respondents. And so we'll delve into that in a few to get through the history of the three city-state empire. But to establish the fact that Rothschilds control the City of London Corporation, on June 19, 1815, Nathan Mayer Rothschild, son of Mayer Amschel Bauer, obtained information that was conveyed through a messenger service to be controlled regarding the outcome of the Battle of Waterloo. By driving the sale of British consols early, which was government bonds, he made it appear that Lord Wellington had lost the battle, which led to the crash of the London stock market. This weakened the Bank of England, providing the respondents an opportunity to take control of the Bank of England located in the City of London, the financial district also known as the Crown. Then in 1829, the respondents purchased Jerusalem with a stolen bounty from the City of London. When the respondents purchased Jerusalem, the respondents then manipulated the fulfillment of revelations, wherein a 6-day war was orchestrated in 1967 by the respondents, thereby using the Israeli people as cannon fodder, while the respondents stripped the land of all its natural minerals and resources, using 400 separate mining companies to fulfill the task. Now, I'm going to pull this up. This link here will bring you to this link here. So this was a publication in the Niles Weekly Register, which was a small-sized newspaper out of Baltimore, began in 1811. It was a primary source for national political news on the first half of the 19th century, wherein it reads, Jerusalem, with a text beginning, there is a report that the Rothschilds purchased Jerusalem. We see nothing improbable with that, and the pecuniary distress of the Sultan, more. He should sell some part of his dominions to preserve the rest, but that the Rothschilds should purchase the ancient capital of their nation. They're wealthy beyond the desire, perhaps even of avarice, and so situated, it is reasonable to suppose that they may seek something else to gratify their ambition that shall produce most important effects.
Okay, so I'm sorry, that's the same process that they work over here, which is he gave the Sultan a loan. And the Sultan couldn't pay it. Why? Because the interest was so high. The interest went through the roof, plus they never printed the interest. So he took Jerusalem, he stole it. Same way they do this to everybody. It's the same process. If you'll read that, you'll see what I'm talking about. Go ahead. Okay. I caught it when they said that. The Sultan is the difficulty. Go ahead.
If secured in a possession in which may be brought about by money, they might instantly, as it were, gather a large nation together, soon to become capable of defending itself and having a wonderful influence over the commerce and condition of the East, rendering Judea again the place of deposit of a large portion of the wealth of the ancient world. To the Sultan, the country is of no great value, but in the hands of the Jews, according to this article, directed by such men as the Rothschilds, what might it not become, and in a short period of time. The Sultan is in great difficulty. Baron Rothschild was proceeding to Constantinople, and the second rebuilding of the temple is not amongst the most strange things expected in these strange times. Now, I've requested that the Special Prosecutor Keith could explain to the court as to why the respondents would purchase Jerusalem and why this may be significant as to any alleged authority.
I think number one, they hijacked the New Covenant. In other words, to make it appear on earth that they had some kind of authority over the New Covenant. And number two, to take as many minerals as they possibly could. And we have personal experience with that. There are 400 companies there. Netanyahu knows exactly what's going on. They're pulling oil out of northeast Israel now. They've been doing this. This has all been being set up and everything. Because, when you do the word God, it's gold, oil, diamonds. That's all they've been after for years. Ever since the Rothschilds have gone from generation to generation. And yes, we go from 1800 or 1829, I believe, and then shoot right up to 1967. Well, these plans are all put in place from generation to generation. They think 100 years down the road, 150 years down the road, not within their own lifetime. Because remember, they worship Satan and Lucifer. So if that's the case, then what their idea is that they work in his timeline. And so when they do plans could be 150 years later. They could be implemented. Not in this specific human being's lifetime, it would be in their so-called God's lifetime. I say so-called because servants can't become a god. So there you go.
Moving along, the bonded indebtedness of the world is stolen assets by the crown and therefore controlled by the respondents. The Temple Bar is the juristic arm of the crown and holds an exclusive monopoly on global legal fraud through the Bar Association franchises. And again, this information is all over, well known. The Temple Bar is comprised of 4 Inns of Court, 2 which are the Middle Temple, Inner Temple, Lincoln's Inn, and Gray's Inn, which is similar to the Mosaic law structure.
Okay, now keep in mind, when they do this, there's a specific case, any unlawful act is no act at all. And the Rothschilds know this. You can go tell. What they do is they give the appearance of ownership, when in fact it's own nothing, control everything. That's their motto. So, along with the Rockefellers. Even though the Rockefellers are they're not the respondents today. What I'm saying here is that they give the appearance of ownership, meaning they took something, but a fraudulent act is no act at all. So the real process is to sever your intangible property to the property. So for instance, you have a house foreclosure, okay? The house was already paid for when you signed the promissory note, because the promissory note was deposited into a bank account and they wrote a check off of it. When they did that, the bank said that the loan was paid for, or the loan was paid, otherwise you're check kiting. Okay, so the clock starts when you start making payments, because that's the scheme to sever your intangible property to that house. That's all they have to do. And give it the appearance of ownership. The appearance of ownership is there to the rest of the people. Oh, well, the bank bought it back. Well, the bank can't buy it back. They don't have any more money to create. That's an appearance of an auction. That's an appearance of something, that the bank has the money to buy that back. What are they going to do? Use your money to buy it back? Doesn't make any sense. Banks are not supposed to own property. So all those are appearances. So what they're doing is they're severing, in your mind, severing your intangible property right to the property. Very difficult to get people to understand that. That property is still theirs, and anything that they do with it you're still liable for it, no matter what. You're still liable for the property. You can legally still be sued if that property is sitting there and it's empty, and it says, oh, the bank has owned it. No, the bank just has control of it through intangible property rights, stolen intangible property rights. And if anybody gets hurt on that property, they can still go and sue the former owner. Just by walking on it and stumbling or hitting their head or whatever, those people can still be sued. And then what the lawyers will do is they'll come up and say, oh, no, you can't sue the bank. The bank has immunity. It can't be sued for anything that happens. It's not liable for anything. Why? Because it's not the owner. The previous owner is still the owner. So this is a process by which the Rothschilds come in and they cloud many titles, because there's no actual transfer of property when they come in. It's only the appearance of transfer and the severance of intangible property to to the home. The appearance of the severance of intangible property to the home. Okay, so that's all. The best way to explain that thing.
Wouldn't that be fair to say that in that scenario it's also economic slavery, severing in that scenario, severing the alleged homeowner's intangible property rights to tangible property, and basically using the person's energy as a caretaker of the land and never being able to pay anything off because it's a legal impossibility created.
Oh, it's out and outright theft if the man actually owned the property, but if he's a slave, he never owned anything. So that's slavery. Basically, what it does is they treat you as a slave. It's you're just renting it to them. That's why they say that you're a tenant. You're an owner until you're a tenant. They keep switching titles and all this other stuff because either way, you're just an object, a part of the property. Your property itself to them.
Are you implying that this is a socialist system where they're stealing from someone to give to someone else?
Same difference, yeah. Politically, yeah, you could look at it that way. Robbing Peter to pay Paul. I believe that's where that statement came from. It's a whole doctrine of how you cunningly steal from people. They have no idea you just did it. You're doing it right in front of them. They don't recognize it as a theft. They don't recognize it as well, it's not a theft because blah, blah, blah. Okay, then now I'm a slave because apparently I'm the property too. So they take all your equity. Well, the only way that somebody can take equity from someone else and do it legally is through slavery. So basically, which is it? Am I a slave, or are you stealing from me?
Right.
That's the question.
That's the question.
The answer to either one side is the violation of all 30 articles of the UDHR and slavery. What else can you say? I'm sorry, go ahead.
No, that's okay. So to point out the further nefarious acts of the Crown, to have the false Declaration of Independence recognized internationally, Middle Templar King George III, at the time of the Treaty of Paris, he was recognized as Prince George III, but eventually became King George, agreed in the Treaty of Paris of 1783 to establish the legal Crown entity of the unincorporated United States. The lowercase t, this particular entity broke the chain of title that was established under the Articles of Confederation, with the entity being an uppercase T in the name of the nation. King George III also placed himself as arch-treasurer to this entity, which again is a grievous violation of law of nations. The colonies are referred to internally as Crown Temple States. This created the foundation for the U.S. states, lowercase s states, which are legal states within the original states of the Union, established from 1774 to present time under the Articles of Association and Articles of Confederation. So, let me see if all can see that. So he did name himself as arch-treasurer of the incorporated Crown entity of the United States of America.
And keep in mind that entity on record didn't really exist, that everybody knew about it until 1789. It never existed because it was placed in their preamble 6 years later. When the actual established government was the United States of America, that was completed in 1781, that started in 1776. From the original article or Declaration of Independence, which was the real one, the real Declaration of Independence, not the fake one that was done by that other guy. It'll come to me in a minute. I keep forgetting his name.
Adam Weishaupt.
There you go. Thank you.
And so this link will give you a full text of the preamble. Now, bar attorneys in the United States owe their allegiance and pledge their oaths to the Crown. All bar associations throughout the world are signatories and franchises to the International Bar Association, located at the Inns of Court and Crown Temple, with their global headquarters located at London, England. Furthermore, the Crown Bar Association's the creation of the respondents. Now down here is an excerpt from Fruit from a Poisonous Tree by Juris Doctor Melvin Stamper. It's extracted from page 58. So furthermore, the Crown Bar Association's the creation of the respondents are actively barring the inhabitants from their original state governments formed into a republic, having never published a written social compact agreement from the inhabitants, which forms the basis of a legal society. Now, Colonel Edward Mandelhaus, who was the agent provocateur of Rothschild, the head of the European Central Banks, was assigned to oversee the President and the Congress in the implementation of the central bankers' plans. House is attributed with giving direction and strategy to be implemented by the President and Senators to enslave the American people with the passage of the Federal Reserve Act and Amendments 16 and 17. Support for the legal presumption that the American people had volunteered to participate in the United States democracy was legislated within the 17th Amendment in 1913. In that, participation in federal elections for U.S. Senators established the legal presumption necessary in determining that you were a federal citizen. The scheme also provided for the control of the courts via the 1913 creation of the American Bar Association. And so what Stamper is referring to here is the creation of the judicial division within the American Bar Association established in 1913. And so that set up the foundation for them to come in and eventually hijack the judicial departments of the state constitutions, which you'll allude to and delve into in a little bit in a few minutes. So the scheme also provided for the control of the courts via the 1913 creation of the American Bar Association. Its parent organization was the European International Bar Association, which was the creation of Rothschild. This allowed the international bankers to control the practice of law, in that the only ones permitted to practice before the courts were those who were educated under their brand of law, which was only admiralty and contract law. Common law for people was to be replaced, as it gave the natural man many jurisdictional protections from the bankers' legislation. When the Congress made its first attempt to throw out common law and replace it with admiralty and contract law, the Supreme Court rejected the proposed rules of court, explaining that the proposed rules would bring into existence a national police state. The Roosevelt stacked the High Court and waited for a case upon which the demise of common law could be accomplished. Erie Railroad versus Tompkins came along in 1938 and gave the court the opportunity the Constitution did not. Therefore, common law at the federal level was to be no more. These facts are proof that respondent-controlled associations are actively rendering the inhabitants to an inferior status of statelessness as defined within the law of nations, thereby treating the inhabitants as property in violation of all 30 articles of the UDHR. Quote, Law of Nations, Chapter 18, Book 1, Establishment of a Nation and a Country. Paragraph 213, Inhabitants. The inhabitants, as distinguished from citizens, are foreigners who are permitted to settle and stay in the country. Bound to the society by their residence, they are subject to the laws of the state. While they reside in it, and they are obligated to defend it because it grants them protection, though they do not participate in all the rights of citizens. They enjoy only the advantages which the law or customs give them. The perpetual inhabitants are those who have received the right of perpetual residence. These are kind of citizens of an inferior order and are united to the society without participating in all its advantages. The children follow the condition of their fathers, and as the state has given to these the right of perpetual residence, their right passes to their posterity. Now here's evidence of the hijacking of the state constitutions. Further, the respondents of bar associations have amended state constitutions as evidenced herein from judicial departments to judiciaries, and made a requirement to be a member of their private membership association to be able to qualify for a position in the newly reformed judiciary. Further, the Florida bar into the Constitution itself without any pocket vote whatsoever, and have been terrorized the inhabitants of the state of Florida ever since. The same thing has happened in many states around the same time. So this is Article 6 of the Florida Constitution before 1968. There's a link to that. And after 1968, you can see there's no notes made towards the change of the term from judicial department to judiciary, and they have a whole new set of rules and procedures, as well as...
Good evening, everybody. Elections have consequences, as former President Barack Obama once reminded us. And his vice president is now leading this nation. And in less than a week in office, President Biden is only further dividing the nation, even as he calls for unity, endorsing the radical Dems' continued persecution of his predecessor, Donald Trump, who is now a private citizen after all, and President Biden approving the sham impeachment process launched by Speaker Pelosi and Senator Schumer with the complicity of Republican Senators McConnell, Romney, and Marshall, and other rhinos. And today, all of the senators of both parties were sworn in as jurors for the impeachment trial of that private citizen, that former president, President Donald Trump, who is obviously, even to the vile and vicious radical Dems, obviously no longer in office. The radical Dems don't care, and seemingly the rhinos don't either. They both want to further persecute the man they've sought to destroy since he won the Republican presidential nomination in 2016. No matter the cost to the nation, the division they exacerbate and enlarge. The Democrats and the deep state and the left-wing national media, along with their masters on Wall Street, K Street, and Silicon Valley, have not been held to account for a single venal act. And there have been hundreds of such acts committed as they spawned phony FBI investigations, created false dossier, put together a special counsel, and now 2 impeachments, defrauding and duping willing courts and agencies, and all with the averted eyes of a corrupt federal judiciary. Radical Democrats so emboldened that they now, in front of all America, knowingly violate the U.S. Constitution as they slither across the floor of the U.S. Senate, intent on destroying one man and devastating 74 million Americans who supported his agenda and voted for Donald Trump. The Constitution they violate, without conscience, is clear and unequivocal on the point. Quote, "The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment." Removed from office. And also straightforward and plain, when the President of the United States is tried, the Chief Justice shall preside. The President, the Chief Justice. The President isn't in office and the Chief Justice isn't presiding. What a sham. Senator Rand Paul took to the Senate, making the point this is nothing more than the radical Dems' endless effort to overthrow Trump and his agenda.
This impeachment is nothing more than a partisan exercise designed to further divide the country. Democrats claim to want to unify the country, but impeaching a former president, a private